Tractate Shevuos discusses the laws of oaths. Oaths are extremely important and significant, being legally binding and have many forms. There are oaths to do a particular action, there are oaths of testimony, oaths by monetary claims, and there are court-imposed oaths for various reasons, along with several others. Chapter 1 will begin the discussion of these laws, and also many principles of atonement through offerings. The first Mishnah says, there are two types of oaths, which are actually four. Some additional points. Liabilities for impurity by temple sanctity have two types, which are actually four, and prohibited transfer between domains on Shabbos have two types, which are actually four, which was actually described in the first Mishnah of Tractate Shavuos. Additionally, appearance of tzara'as, leprosy, is of two types, which are actually four. The points on liability for impurity by temple sanctity are that if the individual was aware that he was impure at the beginning and at the end when he actually ate sacrificial foods or entered the temple, but was unaware in between, he needs to bring a specific type of offering. If he was aware in the beginning but not at the end, then the Yom Kippur service will atone for him until he becomes aware, at which point he must bring his offering. If he wasn't aware before and was aware at the end, the Yom Kippur service atones for him. If he was totally unaware of his impurity throughout the entire thing, some say the he-goats of the holiday offerings atone for him, along with the Rosh Chodesh offerings. Others say just by the holiday offerings, as the Rosh Chodesh offering is to atone for somebody who ate impure sacrificial foods while they were pure. Others say these offerings atone for the same things. There are further opinions as to which offerings atone for which violations by these laws, which can be summarized essentially into this chart here. It mentions the atonement purposes of various other offerings. The Gemara explains, in regards to the order of tractates, the prior one was Tractate Makos, and Tractate Shevuos is next, as one of the last things in Tractate Makos was the liability for shaving your beard, and it mentioned several related prohibitions which have multiple penalties. So the next discussion in the next tractate was on various laws with one type which actually have two parts. It mentioned those laws of impurity here by the laws of oaths, as those are taught next to each other in scripture and have similar offerings brought for the violation. And unlike the other mentioned laws, those are pretty short, so it just mentioned them all first here. The oaths, which are two, but actually four, are, for instance, an oath that I will eat, or that I will not eat, or that I ate, or that I did not eat. On the laws of impurity in the temple, there are two, which are four, which are a person being unaware that he's impure while eating sacrificial foods, and being unaware he's impure while in the temple, and for eating the actual sacrificial food or for being in the temple. The two which are for by domains on Shabbos are taken from a private domain into a public domain, either as done by the inside or outside individual, or bringing the item inside from a public domain from the inside or outside individual. The two which are for by tzara'as, impurity, are the unique marks of the se'es and the baheres, and both their subdivisions. It also debates the author of this Mishnah in accordance to the various opinions that hold by these laws. It's debated in regards to their opinions as to the received punishment for violating these prohibitions. It specifically argues if the opinions on the received punishment for these violations, in this case of lashes, lines up with the opinions on the punishment for the violations by the tzara'as impurities, which it does not. So it's argued as to who the source of these points are. This is debated further. If it discusses this topic, some hold by these laws, even a basic awareness level and understanding of the laws of impurity is sufficient by these laws, which some individuals didn't even have this basic level of understanding if they were brought up amongst non-Jewish people, for instance, and were never taught these laws. It also clarifies, it goes into much less detail by the two which are for of domain transfers by the laws of Shabbos here, than it did in the actual discussion in Tractate Shavuos, which properly discusses those laws, including additional cases of non-liability too. These are described, and again, they're all properly listed in the first Mishnah of Tractate Shavuos. It additionally clarifies who holds like these opinions in regards to the different skin shade discolorations of tzara'as impurity. Some say it's like the opinion that the four different off-white shades of discoloration combine in order of the level of discoloration, and it brings sources for this opinion stating this. It also qualifies the exact order of color shades in regards to the laws of tzara'as leprosy as to what is the least or greatest discoloration, along with scriptural sources, and it brings an analogy of different kings and subordinates to show the order of levels of intensity of these skin discolorations. It further goes through the points on unawareness of impurity as to the levels of punishment that were applied for the violation of these laws, along with sources for the prohibition against eating sacrificial foods while impure, and additionally for being in the temple while in states of impurity. There are additional points on these laws. It further qualifies as to the specific different offerings in the temple as to which violations they atone for. These particularities are discussed along with their sources, and it additionally goes through the uses of all these offerings with further sources for the Yom Kippur offerings, the Rosh Chodesh offerings, and the others. It also goes through what the holiday he-goat offerings atone for in regards to impurity violations within the temple. It goes through the related verses as to how they imply which functions. The opinions on this topic are further discussed as to the purposes for these offerings, There are additional points on this. Some say that the daily offerings that were not needed for the community can be redeemed even if they're blemished. Others disagree with this, saying that redemption doesn't remove the sanctity of the animal. Others say such a concept only applies to incense. It additionally debates as to whether incense or unblemished communal offerings can be redeemed, in spite of the fact that they still retain a degree of physical sanctity. It also discusses the sanctity of the red heifer offering. It said if it dies, it can be redeemed, as even a small piece of its hide is valuable. There are additional points in these laws by other types of offerings. It also mentions some just had a tradition that daily offerings can no longer be redeemed at the end of the year, while others disagree. According to the first opinion, he'd say the excess daily lamb offerings should all just be brought as communal ola offerings, although the leftover he-goat chatas offerings should not be offered as an ola, so those should be instead sold and have extra offerings purchased from the proceeds. This principle is sourced from some additional discussions. Similarly, it's also mentioned in other sources that at the end of the year, excess offerings would be brought on the altar, similar in concept to desserts. It's a debate if this end of the year excess offerings included the bird olas or not. Anyways, then the Mishnah had stated that the he-goat of the Yom Kippur service atones for deliberate impurity violations within the temple. It quotes the scriptural sources for this concept. Also, it had stated that the Azazel goat offering on Yom Kippur atoned for biblically sourced transgressions, be they light or severe, or deliberate or accidental, whether they're punished with kares, divine punishment, or capital punishment, or otherwise. It actually explains, to prevent redundancy, that this list is explaining the different severities of transgressions. That light transgressions are positive and negative commandments, while severe transgressions are those punished by kares, or capital punishment. Now, if somebody typically violates a positive commandment and repents, they're forgiven. So the necessity for the Azazel offering to atone for him must be that he's, in this case, refusing to repent, and in accordance with the opinion that the Yom Kippur service atoned even for unrepentant sins. He sources this from verses, although others still dispute this, quoting additional sources and comparing this to other offerings. It also clarifies that Yisraelim, Leviim, and Kohanim all receive atonement from the Azazel he-goat offering in the same manner, although there is variation for impurity transgressions in the temple, where that also atones for such a transgression for non-Kohanim, but Kohanim require the bull offering to atone for impurity violations in the temple. Others disagree with this and say, well, all these groups can receive atonement. The specific offering varies, and he holds the Azazel goat offering doesn't atone for Kohanim. It additionally debates sources. Also, according to the opinion that Kohanim are atoned through the Azazel goat offering, it's questioned why there are two confessions cited over it, along with the throwing of the blood, and it's explained to be done for the Kohen Gadol himself, and then for all the other Kohanim, as it's better that an innocent person come and request atonement for a group of guilty people, as opposed to a guilty person asking atonement for a group of guilty people. And that's the end of Chapter 1. Chapter 2 of Tractate Shevuos continues covering the various laws of atonement through offerings and laws of impurity before covering the laws of oaths. The first Mishnah says, regarding the principles of awareness of impurity, there are two types that are actually four. If a person becomes impure and then forgot that this occurred, but remembered he was eating holy food of an offering, or somebody forgot that the food he was eating was holy, but he remembered that he was impure, or somebody forgot that he was impure and that the food he was eating was holy and only realized afterwards. In all these cases, the man is subject to bring an Ola V'Yored offering. If somebody became impure and then forgot, but remembered he was about to enter the temple, or he forgot that he's entering the temple, but remembered he's impure, or he forgot both and only realized his wrongdoing afterwards, he would also be subject to bring an Ola V'Yored offering. This would apply to entering the temple courtyard or additions to the temple courtyard, which are only made with the consent of the king, a prophet, the Urim V'Tumim, and the Creator Sanhedrin, and was done with the Thanksgiving loaf offerings and songs. Making an addition to the courtyard temple was done by the court marching around the area to be added, with two Thanksgiving offerings being carried behind them and all of Israel behind them. The inner Thanksgiving offering was eaten, and the outer one was burnt. If an addition to the temple courtyard was made without these requirements, there's no liability for entering within that area while impure. If a person became impure while inside the actual temple courtyard but then forgot, but he remembered the fact that he was in the temple, or somebody forgot that he was in the temple but remembered that he was impure, or he forgot both and bowed down, or waited long enough to bow down, or left the temple via the longer exit, in those particular cases, he's liable. Related, if the Sanhedrin or a Kohen Gadol makes a mistaken ruling on these laws regarding the positive commandments of not being impure within the temple, there's no liability of a chatas offering. An example of a positive commandment that there would be liability for incorrectly ruling on would be if a man was cohabiting with a woman, and she suddenly finds that she's menstruating in the middle of the act of cohabitation. thereby making her have nida, impurity, meaning cohabitation with her at this point is forbidden. The man in this case is forbidden to physically withdraw from her immediately, as that constitutes part of the act of cohabitation, which in this case is forbidden. It's debated between a few opinions based on several verses as to where there's liability for being unaware of impurity, between lack of awareness of a sheretz creature, lack of awareness of being within the temple, and lack of awareness of being impure. The Gemara asks, the Mishnah prefaced by saying there are two that are for laws of awareness of impurity, and then it went and listed way more than this. So some say it's only counting the last 4 cases that make somebody liable to bring an offering, others say it's only counting the first 4, which are unique and unusual and are not mentioned throughout the Torah. It's also asked, what if somebody touches a sheretz creature, which he knows that the sheretz creature causes impurity, but it's the size of a lentil in this case, and he's not sure if a piece that small generates impurity. In that case, stands unresolved. Also, if somebody traveled to Jerusalem and entered the temple, and he knew that the temple existed somewhere, but he just wasn't aware that the building he was in at the moment was the temple, that's also unresolved if there's liability for impurity in such a situation. Also, the points on how additions to the temple courtyard were established are sourced from scripture. It discusses these along with the Thanksgiving loaf offerings that were used in the ceremony. Others actually say that it was the remainder of the mincha offerings that were used in the ceremony to expand the temple courtyard, saying that it should be sanctified through an offering that can only be eaten within it. This is additionally qualified as saying an unleavened loaf must be used, as there were no viable sacrifice options with leavened loaves. It also clarifies the songs that were sung during this ceremony of expanding the temple courtyard, listing psalms and musical instruments and similar, and it clarifies the remaining points of the procession. For instance, is debated as to how the Thanksgiving offerings were carried. Some said beside each other, according to which the inner loaf, as described, was the one closer to the wall, based on the words of the prophets, while others say that they were carried one behind the other, where the inner loaf that's eaten is the one that was carried behind, as since it goes second, it's entering into a consecrated area. Additionally, it's a debate if the ceremony for the addition to parts of the temple courtyard required all of these steps or any one of these steps. It debates this from a few sources. It's also argued as to whether the initial consecration of the original temple area is permanent or if it was removed after the destruction of the temple. Anyways, it quotes the source that if somebody becomes impure while in the actual temple, there's liability, which are then discussed further. Also, when it said that if somebody forgets both that he's impure and also that he's in the temple, if he bowed or waited long enough time to bow, he is liable to bring the offering. Some say this only applies if he bowed towards the sanctuary, but if he bowed in the opposite direction, so long as he didn't also delay, he's not liable. It mentions that there's variation between methods of bowing. Apparently, the one that doesn't involve delaying is just kneeling. Bowing that involves a delay includes fully prostrating oneself. It's also an argument as to how long this delay is, and it's between the length of time it takes to recite either of 2 listed verses. If somebody delays in the temple while they're impure, it's also an argument as to if there's a penalty of lashes, which stands unresolved. Similarly, if somebody delayed in the temple courtyard but was suspended in the air, that stands unresolved. It's also unresolved if there's liability for intentionally impurifying oneself within the temple. Also, if a nazir is standing on a grave, it's unresolved if there's a penalty of lashes if he delays while standing there. Anyways, we said there's also only liability if somebody forgot they were impure and in the temple if they left via the long exit. This means there's no liability to leave via the short exit, even if he decides to walk super slowly and take all day. As for a case if somebody delays through several very brief intervals, that stands unresolved. It's also asked, what if somebody left the temple via the long exit, but went really fast and took as long as taking the short exit? It's debated if he's still liable in that case. It's discussed further and it cites additional laws of impurity. It also clarifies the final points on impurity and liability in the case of cohabitation of a nida, when it says there would be liability for 2 chatas offerings for moving in both directions. It quotes sources for this concept, and it mentions in such a situation, if somebody is cohabiting with a woman and suddenly finds that she's menstruating, he should just stop moving and wait until he's limp before then withdrawing so as to prevent any further acts of cohabitation. This also shows that cohabiting with a flaccid organ does not legally constitute cohabitation, although that's debated. It discusses this further, quoting additional sources, along with additional verses sourcing the prohibitions against cohabiting with a menstruating woman, and the steps to prevent this, such as not sleeping with one's wife during that general time period, which is said to be a very meritorious thing. Somewhat related, it said that it's a very meritorious thing to do the Havdalah ceremony at Shabbos' conclusion. Also, it said that if somebody cohabits with their wife in a modest manner, they'll merit to have sons, which is based on a verse. It additionally discusses the remaining points from the Mishnah, debating between the verses as to certain liabilities for particular unawareness with impurity and otherwise. These are additionally discussed. And that's the end of Chapter 2. Chapter 3 of Tractate Shevuos begins the discussion on the various laws of oaths. The first Mishnah says, oaths are of 2 types that are actually 4. There are, for example, somebody taking an oath that he will eat, an oath that he will not eat, an oath that he ate, and an oath that he did not eat. If somebody swore an oath to not eat, and then ate any amount of food, he's liable. This is unlike typical prohibitions against eating, where the minimum forbidden volume is an olive-sized portion, as here the issue isn't the food he's eating, it's the violation of his oath. The Gemara debates the translation of the first oath with the word she'achal, that he will eat. Here this is defined as stated, however elsewhere it's defined as a vow to abstain from eating, as the context is that the man is being pressured to take this vow. Alternatively, the vow to abstain from eating isn't when the man said she'achal, it's when he said she'i achal, which means that he won't eat, and it's not just assumed to be a mispronunciation. It also debates what words can be used to introduce the taking of an oath, such as mifta, an utterance, or isar, a prohibition. This is discussed further. It also mentions how these principles apply within the laws of vows, unlike this, which is discussed in the laws of oaths. Additionally, when it compares the 4 types of oaths, 2 of which were on events to take place in the future, so could become false oaths, and 2 of which were on events that took place in the past, so which could become vain oaths. It's comparing them to show that there's a penalty of lashes in all of these circumstances. Alternatively, it's suggested that they're compared to show that for both false and vain oaths, there's an offering brought. Others just have a totally different definition as to what a false or vain oath is, saying that a false oath is somebody swearing that he ate something or did not eat something, as mentioned, while a vain oath would be somebody taking an oath on something universally known to not be true, such as something like taking an oath that a man is actually a woman. It argues on the sources for this principle. Anyways, regarding the opinion that the minimum amount to violate an oath against eating was said to be any amount, in accordance with the opinion of Rabbi Akiva, this was debated by the sages, who said it had to be an olive's volume minimum, as mentioned. A similar debate exists between others for all prohibitions, but this was specified here by laws of oaths to show that the sage's opinion applies here even when the amount was unspecified. Others just suggest that this is specified as Rabbi Akiva only holds his unique opinion here by laws of oaths, as there was no specification of amount. The debate is further from a few related discussions, and seem to prove that this is the only time Rabbi Akiva debates the sages on this. Additionally, by other laws, there's liability for eating impermissible foods in amounts less than an olive volume if the food was an entire creature, such as a whole ant. Also, if somebody eats consecrated property worth the minimum value of a peruta coin, but with less than the minimum volume of an olive, there's still liability by the same logic. It qualifies the remaining points. Also, this dispute between Rabbi Akiva and the sages is only when the amount in the oath was unspecified. If it was specified, it's agreed that there's liability for eating even a tiny amount, as it's comparable to the case of eating an entire creature. Also, this is said to be the case of taking an oath to not eat. If the man said he wouldn't taste, that applies to any amount. Also, this is by oaths. By koinomis, a type of vow, this would again apply by any amount. This is qualified. There are other points. If somebody takes an oath to not eat and then eats dirt, it's unresolved if there's liability for doing so in a small amount, or if somebody takes an oath against eating grapeseed, it's unresolved what the minimum for liability is, as such a thing is typically eaten with a full grape. Related, it's also asked, what if a Nazir, who's anyways not allowed to eat any grape product, then takes an oath to not eat grapeseed? As the principle within the laws of a Nazir is that they can't eat an olive's volume, but perhaps he also meant to prohibit to himself less than this when he took this oath. Based on related cases, by eating amounts of non-kosher food, it said that the Nazir's oath applies to an olive's volume of grapeseed and no less. The remaining points on eating dirt still stand unresolved. New Mishnah. If somebody took an oath to not eat, and then he eats and drinks, he's only liable once. If he took an oath to not eat or drink, and then eats or drinks, he's liable twice. If somebody took an oath to not eat, and then he eats wheat bread, barley bread, and spelt bread, he's only liable once. If he takes an oath to not eat wheat bread, barley bread, or spelt bread, and eats all 3, he's liable for each one of these. If somebody takes an oath to not drink, and then drinks multiple drinks, he's liable for 1 violation. If somebody takes an oath to not drink wine, honey, or oil, and drinks all 3, he's liable for all 3. If somebody takes an oath to not eat, and then he eats food that's not fit to be eaten, or drinks something that's not fit to be drunk, he's exempt. If somebody takes an oath to not eat, and then eats improperly slaughtered animals, an animal with an internal defect, or some crawling creature, it's a debate if he's liable. Related, if somebody vows against his wife from benefiting from him if he'd eaten earlier that day, and earlier he had eaten improperly slaughtered animals, crawling creatures, or otherwise, his vow goes into effect and his wife cannot benefit from him. The Gemara says, if somebody takes an oath to not eat and then drinks, we said he's still liable. This is logical, as when people say they want to eat, that typically includes drinking. It's also referenced in scripture, as it brings locations where the word eat is used to reference drinking. It brings further sources for this concept that drinking is included in eating. In the case where the man takes an oath to not eat wheat bread, barley bread, or spelt bread, and then he eats all 3, we said he's liable for eating each of these. This is as he specifically clarified the word bread after each type within each enumeration. Also, we said if somebody swears an oath to not drink wine, oil, or honey, and he then drinks all 3, he's liable for all 3. Again, this is as he enumerated each of them individually by name. Others say that actually this case is defined to be that somebody is requesting another man to drink with him, and this man is taking an oath not to drink any of these, again, by enunciating each of them. Additionally, by the bread case, there's a similar case where somebody falsely takes an oath that they don't have any wheat, spelt, or barley bread. Some say there's liability for each specified type. Anyways, it's a debate if there's liability for the 3 specified types, or also for an additional liability for just the general denial. By our case of somebody taking an oath to abstain from the types of bread, however, there would only be 3 liabilities, as it doesn't make sense that there should also be a general prohibition in addition here. Also, the Mishnah said if somebody takes an oath not to eat and then eats foods unfit for eating, he's exempt. This is clarified to be where the oath was non-specific, unlike the later case of somebody vowing to not eat types of non-kosher foods. A vow like this could exist in spite of the fact that you're already not allowed to eat non-kosher, possibly as the oath also included abstinence from permitted kosher foods in addition, or the oath was against eating these non-kosher foods in less than the prohibited amounts. It explains these opinions further. Others define the case just to be that forbidden foods that aren't kosher are actually considered fit to be eaten, unlike something that's unfit to be eaten, which is something like dirt. There's additional discussion on the opinions of these cases. Essentially, it tries to suggest that if somebody takes an oath against something that was anyways prohibited due to a separate prohibition, but as suggested, it was a part of an inclusive prohibition against something that was allowed, it would take effect. However, there's a case that somebody took an oath before Yom Kippur to not eat dates and forbidden fats, and it only mentioned that there's liability for then eating the dates, unlike the fats, which were already forbidden. So there's a bunch of suggested answers. Perhaps this is unique as the prohibition came about due to the man's own decision, or it's that it's an oath, so it's unique as it could be petitioned to be revoked, or it's that the case is with bringing a variable offering, or it's unique as it's an oath which takes effect on less than the minimum amount, or it's unique here as the punishment for intentionally violating it is only lashes as opposed to kares. Or a final explanation, this case is unique as it's with an oath which could take effect on something non-tangible. New Mishnah. An oath can be taken on something relevant towards oneself or towards others, meaning you can swear to give or not give something to someone, or that you have given or not given something to someone. Also, an oath can apply to things tangible or non-tangible, as you can swear to sleep or to not sleep, which is non-tangible. You can also take an oath on something totally non-beneficial, such as that you will throw a pebble into the ocean or similar. Rabbi Yishmael says there's only liability for accidentally violating an oath that pertains to your doing something in the future, as the verse says, to do bad or to do good, using only future tense, and everything else is learned from scriptural inclusion. Rabbi Akiva holds there's liability for accidentally violating even oaths concerning the past, as if it's based on scriptural inclusion, the principles would apply by all types of oaths. The Gemara says, as discussed in Tractate Shevuos, vows are stricter than oaths, as vows take effect on items needed for a mitzvah, the same as by everything else, which doesn't apply by oaths. Oaths are stricter than vows, as oaths can apply to things that are non-tangible, unlike vows. When the Mishnah gives the example of an oath to give someone something, this must refer to a present to a rich man, as giving to the poor is already an obligation. By the oath to not sleep, this is only allowed if it's for less than 3 days, as more than this is said to be impossible to do. If somebody took an oath on a non-beneficial act, such as to throw a stone into the ocean and didn't follow through with it, it's a debate if there's liability in such a case, as some hold there's no liability if the oath cannot be expressed in both future and past tense. It discusses similar rulings. It additionally debates between these opinions as to whether an oath is required to be able to be formulated in both future and past tense for it to be valid. According to the opinion that says this does apply, this explains why oaths of testimony are in their own category, if this rule doesn't apply there. Those that say this principle just never applies, they say that oaths of testimony are listed separately so as to obligate a person to bring 2 offerings for falsely swearing such an oath. Others dispute this. We also had broad debate as to if somebody is liable for accidentally violating an oath that pertains to the past between Rabbi Yishmael and Rabbi Akiva. It additionally discusses sources for these opinions and where and how they expound them, quoting a number of different verses on this topic. Related, it said there's liability for violating an oath even if the person forgot it existed, which is based on a scriptural quote. However, it then says there's no liability if only the item in question is concealed. It argues as to what this last case could possibly mean, and suggests it could be something like a man taking an oath to not eat wheat bread and then reached to take barley bread but accidentally grabbed wheat bread and thinking it was barley bread he then ate it. If both the item was concealed and the oath was also forgotten, it's argued if there's liability in such a circumstance, and it seems to say there is an exemption there. It said that there's exemption for bringing an offering if somebody's false oath was just totally due to a mistake. According to this, there would still be liability for swearing falsely on a past event, in the case where somebody says he knows the oath was prohibited, but he's just not sure whether there's liability for an offering on it. A case, if somebody took an oath to not eat a loaf of bread, and then really wanted to eat the bread, and then forgot about his oath and ate it, as he would have eaten it anyways if he had been aware it was prohibited at the time that he had eaten it, it said that there's no liability for an offering in that case. Related, it's also argued as to if an oath must be actually spoken and not just thought. New Mishnah. If somebody swears an oath to violate a mitzvah and does not end up violating the mitzvah, he's exempt. If he swears to fulfill a mitzvah and doesn't fulfill it, he's also exempt, although others disagree and say there's liability. The opinion that says there is liability holds this, as if somebody's liable for breaking an oath on something that there was no oath at Mount Sinai to perform, for sure he should be liable for breaking an oath to do something that he had already taken an oath on to do at Mount Sinai. The others disagree with this, as they say it's being compared to the first case, that if somebody swears to violate a commandment and does not do so, they're exempt. The Gemara brings scriptural sources for this concept, which are then discussed. Essentially, the verse on this topic states, to do bad or to do good. It tries to derive that this implies liability for violating oaths only applies to optional matters, which it discusses further. Some derive this from the word or in the verse, as the concept of oaths to benefit others are derived from that, implying the whole thing refers to optional matters. The opinions are discussed further. New Mishnah. If somebody takes an oath to not eat a loaf of bread, and then takes another oath to not eat it, and then takes another oath to not eat it, and then eats the bread, he's liable only once. All this here has been discussing oaths of utterance, which has a punishment of lashes for intentionally violating it, and a variable sin offering for unintentionally violating it. If somebody takes a vain oath, which will be defined a bit later, there's lashes for intentionally violating it, but there's exemption if somebody unintentionally violates it. The Gemara says, the three listed oaths were formatted slightly differently from each other, the first being to not eat a loaf, and the others being to not eat it, which shows that if somebody takes an oath to not eat it, and then swears 2 oaths to not eat the loaf, and then eat the bread, that would result in 2 liabilities. This is because this opinion holds an oath to not eat a loaf has one be liable if he eats an olive-sized portion, while an oath to not eat it has one be liable only when he eats the entire loaf of bread. The Mishnah's case listed 3 separate oaths, as it's showing the latter oaths have no liability, but they do still remain in stasis until they're able to apply. For instance, if somebody made these 3 oaths, the last 2 are in stasis, and if he then annuls the first oath, the second oath takes its place. It argues on sources for this principle. It's also said if a person swore an oath to not eat a loaf and then ate everything besides for an olive-sized portion, he's still able to have his oath annulled. Some say this case is where the man took an oath to not eat the loaf, as the oath applies to each olive-sized portion of bread. Others say the case is where he swore to not eat it, and it's just that he didn't eat the entire loaf, so he's not liable yet. If we debate this from other related cases. Also, if somebody takes an oath to not eat a loaf of bread, but this oath will only take effect if he eats this other piece of bread, and he accidentally ate this first piece of bread, which triggers the oath, and then eats the second piece of bread intentionally, he's exempt from liability. But if the first bread was eaten intentionally, and the second was eaten accidentally, he's liable for violating his oath. And if he ate both by accident, he's exempt, and if he ate both intentionally, it depends on the order. If he ate the conditional piece of bread first, triggering the oath, he'd be liable once he eats the second loaf. If he eats the second loaf first, it's a dispute based on whether a questionable warning is considered to be a valid warning. If somebody has 2 loaves and took oaths not to eat either, but that these oaths only go into effect if he eats the opposite loaf, and then he eats both loaves. If he ate the first, only being aware of the prohibition on the other one, and then ate the other one, remembering that that one he's eating has the prohibition, and forgetting the prohibition on the first one, he's exempt. If he ate the first loaf, only being aware of the prohibition on the second, and then eats the second, only being aware of the prohibition on the first, he's liable for having eaten the second loaf. If he ate both loaves accidentally, he's exempt. If he eats both intentionally, it's a dispute if there's liability for eating the first loaf, which is then discussed. There are other questions that if somebody takes an oath to not eat 9 figs, and he then takes an oath to not eat 10 figs, and he eats 10, it said there's liability for violating only the first oath. However, if somebody swears to not eat 10 figs and then takes an oath to not eat 9 figs and he eats 10, he's violated both oaths. It further explains this opinion. New Mishnah. We had mentioned prior the concept of a vain oath. This is an oath which contradicts a well-known fact, such as that a stone pillar is made out of gold, or that a man is a woman, or that a woman is a man. Or it's an oath that somebody saw something impossible, like a camel flying, or a snake like an olive beam press. Or another example would be a witness taking an oath to not testify in court, or somebody otherwise taking an oath to not perform a mitzvah. As mentioned, these are called vain oaths, and there's a punishment of lashes for its intentional violation and exemption for unintentional violation. Also, if somebody takes an oath to eat a loaf of bread and he then takes an oath to not eat the loaf, the first oath is binding and the second one is vain. If he eats the loaf, he's violated the vain oath, and if he doesn't eat the loaf, he's violated the first one. The Gemara mentions when it says a pillar is established to be made out of stone and not gold, this is where the stone was seen by at least 3 people. It further defines the other cases of somebody swearing something impossible occurred, such as that a camel flew. It debates if an oath like this can be considered true based on the swearer's own personal uncommon interpretation of the words For instance, if he made this oath but was referring to a large bird that he had just nicknamed Camel. It's debated this from a few scriptural quotes on related discussions. When it said an impossible oath that a snake was like an olive being press, this cannot refer to its size, as there were such massive snakes seen. So it says it refers to the snake's back being spotted, which was similar in appearance to an olive press. When we brought the case of somebody swearing to eat a loaf and then swearing to not eat it, it mentions there's still liability either way for the second vain oath, whether he does or does not eat the loaf. New Mishnah. Laws of oaths of utterances, as we've been discussing, apply both to men and women, to oaths regarding relatives and non-relatives, to those qualified to testify and those disqualified, to oaths taken inside or outside court, so long as the man swore the oath himself. As mentioned, there's lashes for violating the oath intentionally and a variable chatas offering for violating it accidentally. Similarly, vain oaths apply to all the same individuals, and the punishments are, as mentioned, lashes for intentional violation and exemption for accidental violation. For both of these oaths, if somebody else requested they take the oath and they responded with amen, they're liable. For instance, if somebody said that they hadn't eaten and somebody said take an oath on that and they said amen, if they had eaten, then they're liable. The Gemara mentions if somebody hears another person say an oath and they respond amen, it's as if they took the oath themselves. It brings sources, although others dispute this concept. And that's the end of chapter 3. Chapter 4 of Tractate Shevuos deals with further laws of oaths, particularly on oaths of testimony. The first Mishnah says, the laws of oaths of testimony apply to men, but not to women, whose testimony wasn't typically accepted. It applies only towards non-relatives, as a person cannot testify towards their relatives, and it only applies towards people that are eligible to testify. Rabbi Meir says, if somebody makes a false oath of testimony, he's liable whether it was done inside or outside of court. This applies if the oath was spoken by the man, and as for if somebody else speaks the oath and this man is just verbally confirming its veracity, there's only liability if done in court. The sages say there's only liability for typical oaths or confirmation oaths if they're performed in court. Witnesses are liable for testifying falsely, whether they do or do not know the punishment for doing so. They are not liable if they thought they were testifying truthfully at the time. The punishment for intentionally giving a false oath in court was a variable chatas offering. The Gemara brings scriptural sources for the point that female witnesses are typically disqualified, here being the verse, the two men shall stand before the court. It further clarifies this as to how it specifically applies to witnesses testifying in court, and argues as to whether this verse actually obligates those giving testimony to stand while doing so. From other verses, it teaches that you must always judge your fellow favorably. It further argues as to whether litigants are required to stand while giving testimony. Related incidents on this are cited. Related, it said that if a rabbinical student and an unlearned person are in a lawsuit, the rabbinical student sits, and therefore we also tell the unlearned person to sit, and he can choose to do so if he wants. Incidents are cited on this. Also, in such a situation with a rabbinical student and an unlearned person, the rabbinical student shouldn't arrive early to sit before the judge, as otherwise it would look like he's presenting his case early, which isn't allowed. This would be allowed if it's just time for his daily studies and he's doing so. It's also said that a rabbinical student can choose to not use a court that's less prestigious than himself. This principle applies only to financial law, as by matters prohibited by God, there's no concerns of personal respect. Some say that the dispute as to if you must stand applies only to litigants, while all witnesses must stand. Additionally, the verse, distance yourself from falsehood, teaches a number of different things. That a judge shouldn't defend his incorrect opinion, an ignorant student shouldn't sit before a judge or witness shouldn't judge or testify alongside a colleague, and a judge shouldn't testify according to a testimony he knows is false and just let the responsibility hang upon the false witnesses. Additionally, it teaches that a student sitting before his teacher who sees room to absolve somebody must say so. A student who sees his teacher making an error in judgment should say so immediately and not wait until the end to claim credit. A student shouldn't testify on behalf of a teacher simply because he knows him to generally be very honest. A person shouldn't claim to be owed more money than he's actually owed to try and get the man to just admit he owes the original sum. If somebody owes somebody money and the lender claims more than what he borrowed, the borrower shouldn't deny the claim entirely in court and then admit it outside to prevent himself from needing to take any oaths. If 3 men are owed money from one man, one of them shouldn't act as a litigant, with the other 2 being witnesses. If a rich man and a poor man are in court against each other, they should dress similarly to prevent any biases, and a judge shouldn't hear one litigant's argument or have a case clarified without the other litigant being present. It brings other sources for these principles. When we said that the only people who are liable for a false oath of testimony are those fit for testimony, some say this is to exclude kings. Others say this is to exclude gamblers or a king. Regarding the debate as to whether there is liability for false oaths of testimony fully verbally given outside of court, it explains this is argued from how it's derived. This is discussed further. It also sources the point that witnesses are liable for fully knowing violation of the laws of oaths of testimony and for a false testimony where they don't know the punishment. We also said if a witness completely accidentally gives a false oath of testimony, there's no liability. This cannot be learned as a proof towards the debate which exists by an accidental ordinary false oath, as based on verses they're just not comparable. New Mishnah. The actual case of an oath of testimony is essentially where a litigant requests of witnesses to testify on his behalf, and they say that they're unable to do so and take oaths that they have no knowledge of the case. This can be done verbally by taking an oath that they have no knowledge of the case, or via confirmation by the other person asking them if they're willing to take an oath and them just saying yes. There's liability to bring an offering if this is a false oath. If the witnesses were requested 5 times outside of court to come and they denied each time, if they eventually do come, they're not liable. If they denied each time within court, they're liable for each time for each of these. If they were requested 5 times in court and then denied all at once at the end, they're only liable once, as they can't retract this. If 2 witnesses denied knowledge of testimony at the same time, both are liable. If they denied one after the other, only the first one is liable. If one denied knowing testimony and the other one admitted to knowing testimony, the one who denied it is liable. If there were 2 groups of witnesses and they both deny testimony one after the other, both are liable, as either could have established testimony by themselves. The Gemara says there's an opinion that witnesses are only liable for false oaths denying testimony if they hear from the litigant himself that they should testify and then deny him. This shows that if the litigant is chasing after them and they take false oaths to not testify, they're not liable. They're only liable if they're actually asked to testify. It also starts with the point that witnesses are only liable for falsely taking an oath that they can't testify if that's done within court as opposed to outside of it. When we said that if both witnesses deny giving testimony simultaneously, that both are liable, this is either in accordance with the opinion that it's just possible for 2 things to be done precisely simultaneously, or it's just that they said it within the time it takes to make an utterance, which it defines. We said that if one man testifies after the other, the second is not liable. Others dispute this, essentially arguing over if a testimony that can lead to a monetary payment, if that's considered as if it directly leads to such a payment, which is described further. It argues on some additional cases, particularly a famous case wherein a man grabbed the silver ingot out of the hands of another man, and the other brought a single witness that this had occurred, but the man who had grabbed the ingot admitted he had done so, but only as he was the actual owner of the ingot. It's essentially stated that there's insufficiency on basically every level, as there aren't 2 witnesses, but there is a single witness, so there's no credibility to the fact that the man admitted his guilt. And as he admitted his guilt, he's legally a thief now, so he can't take an oath. So it's simply ruled if somebody would be obligated to take an oath and is unable to do so, he must pay, so here he would be obligated to return the ingot. It discusses other cases of oaths by singular witnesses. If a single witness denies giving testimony on a woman's husband's death, there's no liability if he privately admitted the fact to the widow, but if he refused to tell her and the court, there'd be liability. Then we had said that if one witness denies testimony and the other admits, the denier is liable. This is necessary to state to show this applies even if both deny testimony and then one retracts his denial within a brief period. When we mention 2 groups testifying, it clarifies that both are liable, as at the time of the first group's denial, the second group were related to each other through their wives, so they couldn't temporarily testify. This would even apply if their wives were about to pass away, as they haven't died yet, so this all still applies. New Mishnah. If a litigant requests of a witness to testify that somebody has his deposit, his loan, a stolen object, and a lost object, and the witness takes a false oath that they know of no testimony for him, they have 1 liability. If they take a false oath that they don't know of the deposit, loan, stolen object, and lost object, they're liable for each listed item. Similarly, if somebody asks witnesses to testify that he has in his possession somebody's wheat, barley, and spelt, and the witnesses take a false oath that they don't know of any testimony for him, they have 1 liability. If they take a false oath that they don't know of his wheat, barley, and spelt, they're liable for each of those. Specifically, if somebody asks of witnesses to testify that he has payment of damages or half damages for somebody, or a double payment, or 4 or 5 times payments, or that somebody violated or seduced his daughter, or that his son had struck him, or that somebody had wounded him, or that somebody had burnt his grain on Yom Kippur, where it'll explain there's a financial payment. In all these cases, if the witnesses falsely take oaths to deny testimony, they're liable. The Gemara asks, is there liability for falsely taking an oath to deny testimony on an imposed financial penalty, in accordance with the opinion that if somebody admits guilt, they're exempt from paying a penalty, and specifically according to the opinion that something that can lead to a payment of money is not considered as if it directly causes a monetary payment? It argues this from several listed cases, including our own Mishnah. It essentially proves that a penalty is the same as typical monetary obligations, meaning the witnesses who take false oaths to not testify here would be liable. New Mishnah. If somebody requests of witnesses to testify that he's a Kohen or a Levi, or not the son of a divorced woman, or a woman who had done chalitza, or that somebody else is any of these, or that somebody else violated or seduced somebody else's daughter, or that his son wounded him, or that on Shabbos somebody else wounded him or lit his grain on fire. In all these cases, as there's no monetary penalty, as there's typically more severe punishments, there's no liability for a witness who falsely takes an oath to deny testimony. The Gemara discusses and sources these points that liability for false oaths of testimony only apply to monetary cases. There are a number of these. These are additionally discussed. It also brings some particular cases of incomplete testimony and further explains the sources. New Mishnah. Some additional cases where there's no liability for false oaths of testimony. If somebody asks witnesses to testify that somebody promised him 100 coins and they haven't delivered it, there's no liability if they falsely deny him an oath. as there's no actual monetary claim, such as a deposit. Or if somebody asked men that if they eventually become witnesses, they should testify, they're not liable for this false oath, as the oath came before their knowledge of testimony. Or if the person asked a room full of people to testify for him, if one of them, the witness, takes a false oath to deny this, there's no liability as he wasn't directly addressed. Also, if a person directly asked witnesses to testify for him and they falsely deny this via an oath, but their knowledge was secondhand, or one was relative or otherwise ineligible, there's no liability. Lastly, if the person sent a slave on his behalf or the defendant asked the witnesses to come and testify, the witnesses have no liability if they deny knowledge of testimony with an oath. The Gemara brings scriptural sources for these points. Also, regarding the litigant asking the room full of people that the witness is allowed to deny testimony as he wasn't directly asked, this would apply even if he was directly next to the litigant when he asked this question. It sources the remaining points. New Mishnah. If somebody requested of a witness to testify for him using the words to adjure, or he commanded him to do so, or bound him to do so, then the witness is liable for taking a false oath of testimony. If they swore by heaven and earth, they're not liable. They are liable if they swore by the name of God, which it gives a list of all the names or terminologies which are considered to be names of God. Also, Rabbi Meir says there's capital punishment for blaspheming or cursing one's parents by any of these names. The sages say only by one specific name. Cursing another person or oneself by any of these names is prohibited. It also works to tell the witness, may God strike you if you don't testify for me, so that if he takes a false oath, he's liable, as that's an expression used in the Torah. If somebody said, may he not strike you if you testify for me, or may he bless you, or benefit you, Rabbi Meir says the witnesses are then liable for false oaths. The sages disagree. The Gemara clarifies the particular expressions of requesting somebody's testimony being I adjure you with an oath, or I command you with an oath, or similar. It also further clarifies exactly as to what constitutes the various names of God. It discusses these further, and also prohibitions of erasing God's name, and a few scriptural occurrences like Lot and his escape from Sodom, and the prophet Micha and others, and the names of God used in scripture around their stories as to exactly which ones are considered divine or otherwise. There are further verses discussed and additional points on false oaths of testimony. It brings many specific terminologies, which it defines as referring to an oath. Words like aror, amen can be used to accept an oath. There are a number of others. It sources the debate as to which names of God are considered blasphemy to use improperly. As mentioned, everybody agrees that cursing another or oneself by any of the names of God, which it also sources, is forbidden. It quotes incident in the remaining points. These are discussed, and that's the end of Chapter 4. Chapter 5 of Tractate Shevuos continues covering the various laws of oaths, now particularly on oaths of deposit. The first Mishnah says, laws of oaths of deposit, essentially swearing that you've repaid a loan, apply to men and women, to relatives and non-relatives, and to those qualified or disqualified as witnesses. According to Rabbi Meir, if he spoke the oath himself, it applies whether or not it was taken in court. If he just confirmed the oath, he'd say it's only valid if done in court. The sages disagree and say it could be done in or out of court either way. There's liability for intentionally violating this oath, whether or not you do or do not know the punishment. If he's totally unaware it's false, there's no liability. The liability for violating this oath is an asham offering worth at least 2 silver shekels. An oath of deposit, specifically, is if somebody demands a deposit he claims he'd lent, and the other man says he has no such deposit, and the man requests of him to take an oath, and the man confirms this. If he's lying, there's liability. If the claimant requested the man 5 separate times, in or out of court, to repay his debt, and each time the man denied owing it with a false oath, he's liable for each of these, as each time he could have retracted and admitted that he owes money. If 5 separate people claimed he owed them money, and he swears he has none of their money, and it's false, he's liable only once. If, however, he swears he doesn't have the first one's money, nor the second, nor the third, etc., he'd be liable for each of them. Others disagree and say he's only liable for each of them if he says, I swear, at the end, and others even require him to say, I swear, after each listed person. If somebody requests of a man to repay his deposit, his loan, a stolen object, and a lost object, and the man takes a false oath that he has none of these, he has one liability. If he takes a false oath that he doesn't have the deposit, loan, stolen object, and lost object, he's liable for each listed item. Similarly, if somebody demands of another person his wheat, barley, and spelt that he lent him, and the man takes a false oath that he doesn't have any of those, he has one liability. If he took a false oath that he doesn't have his wheat, barley, and spelt, he's liable for each of those. Some say he's even liable if he mentioned everything in singular, saying a wheat, a barley, and a spelt. There's liability for all of those. If somebody demands another admit that he violated or seduced his daughter, requesting him to take an oath, and the man does so, he's liable for an offering if this was false. Others actually disagree, saying you can't pay a fine due to your own admission. Others say fine, but he still would need to repay the woman for the embarrassment and damage, as discussed in earlier tractates. If somebody claims another person stole his ox and the man denies this, taking a false oath, he's liable to bring an offering. If the man admitted to stealing the ox but denied having slaughtered or sold it with a false oath, he's not liable to bring an offering, as he's only denying a fine. If somebody claims another man killed his ox and the man takes a false oath, he's liable. If he claimed the ox killed his slave and he takes a false oath, again, he's only denying a fine, so there's no liability to bring an offering. If somebody claims a man injured and wounded him and the man denies this, taking a false oath, he's liable to bring an offering. If, however, somebody's Canaanite slave claimed he knocked out his tooth or blinded him and he takes a false oath, as he's only giving a monetary payment, he's not liable to bring an offering. To summarize, as a general rule, anybody that would pay money by his own admission to a claim is liable to an asham offering, otherwise he'd be exempt. The Gemara discusses a case. What if somebody takes a false oath of deposit, as we've been discussing, but he'd been warned not to do this by witnesses prior? It's questioned, as typically people who deliberately commit transgressions don't just bring offerings, but it's a question if there's a difference if he was forewarned. Here, it's explained that in such a situation, he wouldn't bring the offering and he'd instead receive lashes. Others disagree with this, saying that's an opinion that's only held by the minority, and they argue points on it further. It suggested that if the person wasn't warned by witnesses, but he did have witnesses watch him take the deposit, his denial of this by a false oath would not have any actual legal consequence, so he apparently should not be held liable. This is additionally discussed. There are further points trying to prove this principle, but it's essentially disproven. Some suggest that if a person makes a false oath, denying having a deposit that was actually seen by witnesses, there's liability for doing so, while if his deposit was written in a document, he'd be exempt, as the document represents a claim against collateral from the man's land, and there's no offering brought for denying such a thing. Related cases are discussed along with further sources. There are further points from the Mishnah that are discussed. These are qualified. For instance, it defines individual specifications of false oaths towards claimants as creating separate individual liability for each one. Regarding the latter case of somebody claiming a man violated or seduced his daughter and the man takes a false oath on this, one of the opinions stated there's no liability to bring an offering as he's denying a fine. This would apply here, as he holds the only thing demanded is the fine, as opposed to also the monetary payment for embarrassment and damages. This is as he holds that presumably a person wouldn't trade a set fine for a reimbursement which can vary in size, such as the embarrassment and damages repayment. The other opinion would disagree with all of this. And that's the end of Chapter 5. Chapter 6 of Tractate Shevuos covers laws of court-imposed oaths. The first Mishnah says, court-imposed oaths ordered by judges are done for claims at a minimum of 2 silver ma'is coins, or for a partial admission of payment at a minimum of a peruta coin. If the admission is of a different type of coin than the actual claim, the defendant doesn't need to take an oath. For instance, if somebody demands repayment of 2 silver coins and the other says he only has a few of his copper coins, he doesn't need to take an oath. If the man demands silver and copper coins and the man says he only has his copper coins, he could be obligated to take an oath. If somebody claims another man has his 100 denarim and the other denies this totally, he's not biblically obligated to take an oath. If the man said, you have my 100 denarim, and the man says, no, I only have 50, he would be obligated to take an oath, as he admitted to part of the claim. If somebody says another man has 100 of his father's denarim, and the man said he only has 50, even though he partially admitted to the claim, he would not need to take an oath here, as it's as if he's just returning a lost object. If somebody tells another person, I have 100 of your dinarim, and the other man says, yes, this is true, and then later demands the coins, but the first man says he already repaid it, he does not need to take an oath. But if he denied ever having the money, as we know from witnesses that he had admitted to doing so earlier, he's obligated to repay him. If somebody tells another person, I have 100 of your dinarim, and the other says, yes, this is true, but only return it to me before witnesses, and later the first man says he already repaid it, he would need to repay it again, as he had agreed to do so only before witnesses. Some other particular points based on these rules, if somebody says another man has his litra of gold, and the other says he only has his litra of silver, he's exempt from oaths as it's of a different material. If, however, the man said, you have my gold dinar, and the man admitted to having his silver dinar, traces, pundion, peruta, or other type of coin, he would be obligated to take an oath, as all types of coins are just considered to be one general type. If somebody said, you have my kar of grain, and the other says, I only have a lesach of your legumes, he's exempt from oaths, as he admitted only to a different material. If the man said, you have a kar of my produce, and the other says he only has a lesach of legumes, he would be obligated to take an oath, as legumes are a produce. If the man claimed the other had his wheat and the other admitted to only having his barley, there's no oaths, as those are different materials. Others disagree, saying they're actually the same type. If somebody says somebody has his jugs of oil and the man admits to only having empty jugs, it's a debate if they're the same type and whether oaths are required here. If the first man claims the other has his utensils and land, and the other only admitted to having all his utensils but denied having the land, or only admitted to having all his land and denied having his utensils, he's exempt from any oath. If he admitted to owing only part of the land, he's exempt from oaths. If he admitted to owing only part of the utensils, he's obligated to take an oath, as movable properties can require property to combine to require an oath. There are no oaths taken based on the claim of a deaf mute, an insane person, or a minor. We don't impose oaths onto a minor, but you can swear to a minor or to the temple treasury. The Gemara says a person would swear with the words of the oath given in scripture, being, "And I will have you swear by Hashem, God of the heavens," meaning by God's name. This has variation based on discussion in earlier chapters as to what exactly constitutes God's name. It said that while taking an oath, the man should hold a sacred article, something like a Torah scroll or tefillin. Generally, somebody takes an oath while standing and holding a Torah, but a Torah scholar can sit and even in the first place hold tefillin. The oath of the judges are said in the defendant's language. Also, when the defendant takes an oath, the judges express the great importance and significance of oaths and the severity for being dishonest, quoting several verses on this, so the person will take care and only speak the truth. If the man refuses to take an oath, he's excused from the court. If he chooses to take the oath, they further express the relevant points, that the words he speaks must not be based on his own understanding, but based on the understanding of God and otherwise. It further discusses these points and the severe retribution taken for making a false oath, which it says affects the entire world. It clarifies the necessity for all these various points. It said the minimum claim for oaths to be taken was silver ma'os. It's a debate as to whether this is the amount of the denial of the claim or of the claim itself. This argument is based on the interpretation of verses which are discussed. It additionally debates between these opinions, quoting a number of different discussions. Evidently, it seems to hold like the first opinion that it refers to the minimum of the denial of the claim. Now, that minimum of 2 silver ma'os was by the claim between a lender and a borrower who only partially admitted to his debt. If the borrower completely denied any debt whatsoever and the lender had a single witness, the borrower would need to take an oath even if the minimum demanded was a single pruta coin. This is based on a verse. Also, if somebody demanded his wheat and barley and the borrower admitted to owing only one of those, it said he must then take an oath. This is sourced. It's discussed. Others disagree and say the man would be exempt from an oath in this case, and they debate further, although it says the original opinion stands. It further discusses versions of this. Related, it said if somebody demanded his wheat from a man and then was about to also demand his barley, but the other man preemptively admitted to having his barley, it said the court judges whether he was intentionally trying to be dishonest and have him take an oath accordingly. Also, if somebody demanded 2 of his needles and the other man admitted to having one of them, he'd be obligated to take an oath, showing that this whole principle applies no matter how inexpensive the items in question are. Some say if somebody demanded his utensils and a pruta coin from somebody and the man admitted to having the utensils but denied the pruta coin, he's exempt from an oath, as that's under 2 ma'os. But if he admitted to the pruta and denied the utensils, he would be obligated to take an oath. We said that if somebody claims a man has his 100 dinarim and the man denies this entirely, he's exempt from an oath. Others hold that he would still need to take a rabbinically instituted Hessis oath, which is discussed. It further explains the difference between ordinary biblical oaths and Hessis oaths, as a biblical oath cannot be reversed while a Hessis oath can. Others actually say biblical oaths can be reversed, so they'd say a difference is that biblical oaths allow the court to claim a man's property, unlike rabbinic oaths. Others say this actually would be allowed by a rabbinic oath, so they'd say the difference is that by a biblical oath, if somebody's suspect of making a false oath, the other party must then take an oath too, which does not apply by rabbinic oaths. According to the opinion that said a rabbinic oath is insufficient to claim property, in that case he's instead threatened with exile and then lashings to get him to repay his debts. There are related cases. It said if somebody lends money before witnesses, he must then return it before witnesses. If the borrower claims he returned the money before witnesses, but then those witnesses just left the country, he's believed. Others debate this. There's variation on this dispute as to if somebody is believed when they say they repaid a debt before witnesses. A few specific cases on this topic are brought and discussed. There are various other related rulings. We had ended by saying there are no oaths taken on the claim of a deaf mute or an insane person, which is based on a verse, and a minor is not legally allowed to do so. We said that you can take an oath towards a minor or to the temple treasury. Here, the minor refers to where he has his father's claim. This case is discussed further. Essentially, there's a debate in such a circumstance if a person would be brazen enough to deny the entirety of such a claim. It debates who we hold in accordance with. Others simply explain our case where the man is taking an oath to a minor to be that he wants to collect the debt from a man who passed away, so is swearing before his minor heir. When he's swearing to collect from the temple treasury, this is to collect encumbered properties, which it states to show an oath must be taken even here out of concern of theft from the temple. Such a concern uniquely would not apply to an extremely sick man. New Mishnah. There's no necessity to take oaths regarding slaves, notes of indebtedness, land, or consecrated property. If they're stolen, none of these are subject to liability for double or 4 or 5 times payments. An unpaid guardian over these would not swear oaths on any of these, and a paid guardian over these does not pay if any of them are lost or stolen. Some say a guardian does need to swear by consecrated objects only if the owner is responsible for them. There's a debate regarding whether certain plants are treated as land by laws of oaths. If somebody lent 10 grapevines to a man and the man says he only received 5, there's a debate if an oath is necessary here. Also, as a general rule, it says there are only oaths taken on things that can be defined by measure, weight, or number. For instance, if somebody claimed he lent a house full of produce or a purse full of money or similar, and the other man says he's not sure of the exact amount, but it's less than that, there are no oaths taken. But if he said he only had produce up to a window on the house or otherwise, he'd need to take an oath. The Gemara brings sources for all these points. Further scriptural sources for all these are cited. The debate of grapevines have oaths taken on them or not is based on a debate if anything attached to land is considered to be land or not. Others explain the debate to be by grapes ready to be harvested, and the debate is as to if they're considered as if they're already harvested. Regarding somebody testifying that he lent a vague amount of produce where there is no oath, some say that an unspecified household isn't a proper measurement, but a specific houseful would be, and would require an oath. Others disagree, and it's said simply both the defendant and plaintiff need to bring their claims with specific measures, weights, or numbers for oaths to become applicable, and it brings sources for this. There are some particular cases. New Mishnah. If somebody lent another man money, sela, and received collateral, and then lost the collateral, and the lender claims the collateral was a shekel, so half a sela, and the borrower claims it was a full sela, so the same amount that was lent, meaning he owes him nothing essentially, the borrower is exempt from any oath. If, however, the lender claims the collateral was a shekel, and the borrower says, no, it was worth 3 denarim, so he owes a single dinar, he'd be required to take an oath. If the borrower claims the collateral was 2 selaim, and the other man says the collateral was a single sela, he's exempt from any oath. If the borrower claims the collateral was 2 selaim, and the lender says it was 5 dinarim, so he owes 1 dinar, he would need to take an oath. Essentially, the one who had the collateral deposit before it got lost would need to take the oath, so the lender. Otherwise, the borrower will be able to take an oath, and then the lender would reveal the deposit afterwards and completely disqualify the borrower from oaths or testimony, which would be unfair. The Gemara explains that conclusion statement would apply possibly specifically to the second case of the Mishnah, which is explained. If somebody lends 1,000 zuz to another person and he was given collateral of something very cheap, like a sickle handle, if he loses this collateral, he loses the full loan. If the collateral was 2 sickle handles, then he only loses one of those. He doesn't lose half the loan. Others disagree and say he would actually lose half. It debates this principle further. This is additionally discussed. It's explained. There's a debate on this after the sabbatical year, if there's collateral. Some say the full debt is retained, some say only the debt according to the value of the collateral. Others explain this debate to be where the collateral is the same value of the loan, and the opinion which says the debt is released essentially holds collateral is essentially just to be used as a reminder to repay the loan. And that's the end of chapter 6. Chapter 7 of Tractate Shevuos covers the laws of biblical and rabbinic oaths. The first Mishnah says, somebody who takes a biblical oath in court does so and thereby exempts himself from any payment. Then there's a rabbinic oath, which is taken to collect payment. This is done by a hired worker, a victim of theft, a victim of assault, if the opposing litigant is suspect of taking false oaths, and a storekeeper for what's written in his ledger. A hired worker would take an oath to collect payment if his employer falsely claimed he was already paid. Rabbi Yehuda says it only applies if the employer admits to paying part of the wage. A victim of theft swears an oath, for instance, if somebody breaks into a man's house to steal something as collateral for his debt and then claims he took nothing, the other man can take an oath to reclaim it. Again, Rabbi Yehuda says this only applies if the man partially admitted to theft. A victim of assault would swear an oath if somebody entered a man's property whole and left injured, and the other man claims he didn't injure him, he can take an oath to be compensated. Again, Rabbi Yehuda says this only admits if the man partially admits to theft. Somebody suspect of making false oaths, whether because in the past he had taken a false oath, or he's just a dishonest person, somebody who gambles, lends on interest, or otherwise, the other man instead takes a rabbinic oath. If both parties are suspect of dishonesty by oaths, some say the oath returns to its place, which will be defined soon. Others say they just divide the contested amount. Regarding a storekeeper swearing by his ledger, it would be that somebody requests of a storekeeper to give his children or workers some food or change, and the storekeeper later claims he did this based on his ledger, but the children or workers say they never received the food or money. So the storekeepers and workers all take oaths for this and collect money from the employer. Others say these are vain oaths, so they just collect the funds without them. Related, if somebody told the storekeeper to give him a dinner's worth of produce, which the storekeeper gives, and then requested his dinner, so the man said that I already put it in your money purse, he must then take an oath that he had done so. If the man requested this produce, and the storekeeper said he already gave it, and you'd taken it home, he must take an oath that he had done so. It's said that whoever has the produce in their possession has the upper hand here. Similarly, if somebody told a money changer to give him change for a dinner, which the money changer gives, and then requests his dinner, so the man said, "I already put it in your money purse," he must then take an oath that he had done so. If the man requested his change, and the storekeeper said he had already given it, and you'd put it in your purse, he must take an oath that he had done so. It said that a money changer typically won't give a single coin in change until he receives the dinner. As was discussed back in Tractate Shevuos, if a woman admits to collecting part of her marriage contract, she can only collect the remainder with an oath that it was not paid in full. This would also apply if a single witness says the marriage contract was paid. Also, a woman would require an oath to collect her marriage contract from encumbered properties or from orphans' properties. She would also need an oath to collect her marriage contract outside of her husband's presence. Similarly, orphans can collect debts owed to their father with an oath, which it describes. This would apply even if the son was born after the father's death. Some say if people witnessed the father saying the particular document was unpaid, the sons don't need an oath to collect it after the father's passing. The following must all take oaths even without a definite claim against them: partners, sharecroppers, administrators, a woman who keeps a store for her husband, and a member of a household. By any of these, one party can request of the other to swear they've taken none of their property, and the other must then take an oath. This cannot be requested at a later period, but if later on an oath becomes necessary, they can also request oaths for prior incidents. The sabbatical year cancels liabilities to take an oath. The Gemara begins going through scriptural sources for these principles. The reason why rabbinic oaths were instituted for hired workers was because it's a major law, which is described further, although some say it's a lasting enactment. Some say it's just as employers have many workers, so could easily make mistakes, so this was instituted to reduce issues. There are further points on this. It said, by oaths between an employer and employee, this only applies if the employee was hired before witnesses, as if he wasn't, the employer technically had the option to just deny ever hiring this individual. It further discusses this, along with some related points. There are additional particularities brought in these points. It's established that some hold the oath is administered to the worker, even if the wage amount is disputed. There are further points on this. The case of theft, we said, was somebody stealing collateral. The claim has legitimacy, as it's where he saw the thief leaving with something smuggled under his clothing. Related, it's established if somebody leaves somebody's house after hiding utensils under his clothes and then claims he purchased those, he's just not believed. This applies if the original owner does not typically sell his utensils and with items that aren't typically hidden, and if the thief isn't typically a secretive person, and only if the original owner claims that they were borrowed as opposed to stolen, as that would require more definitive proof, and only regarding items that are typically borrowed or rented. And there are supports and some unresolved questions on this. If somebody claimed the thief stole his silver goblet, if the victim is wealthy or trustworthy or somebody who people deposit expensive items with, he can take an oath, otherwise not. Regarding the case of somebody's injury, where he entered a house and left with a wound and took an oath that somebody hurt him, this applies specifically to an injury that could not be self-inflicted, such as a bite mark on his back or his torso, and there was no one else there besides for the alleged attacker. It clarifies the points on vain oaths. We mentioned a gambler and otherwise cannot take oaths, establishing those prohibited by rabbinic disqualification. If both litigants were suspect of taking false oaths, it was a debate, and some say we just don't know what the law there is, others say it's just divided. One of the opinions was that the oath returns to its place, which is explained to mean that the status quo is just maintained, as they have oaths from Mount Sinai anyways to not steal. It additionally discusses sources for this. It also explains the remaining points from the Mishnah, along with some related points on witness testimony. It explains the points between lost collateral. It says it brought cases of both produce and money changers, as produce spoils, so people don't postpone transfer typically, and as mentioned by a money changer, they don't typically give money without first receiving recompense, so both cases are listed. It also clarifies the remaining cases by marriage contracts and orphans. Some held that a lender's orphan can only collect from a borrower's orphan if the lender died during the borrower's lifetime, as otherwise a person cannot give over a debt to their children. Others dispute this, and it's discussed further. There are further points on this, along with several related incidents that are listed. It's a rule that doing like either opinion is allowed, however, generally a document that belongs to a lender's orphan who died after the borrower, we just do nothing with it in such a case, as we're unsure who we rule like. The remaining steps from the Mishnah are qualified setting sources, and it also proves that by partners or sharecroppers, we can require an oath from a rabbinic oath, as they're allowed to require oaths from earlier incidents to be taken based on a later oath. Some clarify this specifically does not apply by oaths of hired workers, where we're more lenient. Lastly, it said that the sabbatical year cancels liability for oaths, which is sources from a verse. And that's the end of chapter 7. Chapter 8, the final chapter of Tractate Shevuos, covers some final laws of oaths of deposit. The first Mishnah says there are 4 types of guardians, say for animals: an unpaid guardian, a borrower, a paid guardian, and a renter. An unpaid guardian takes oaths by everything to avoid liability. A borrower would need to pay for any damage to the item. and a paid guardian or renter swear oaths by an animal that was damaged that they're not at fault, and if the animal was captured or died naturally, they would pay for loss and theft. If an unpaid guardian takes a false oath that an animal under his watch died naturally when it had actually been captured or otherwise, or he said it was captured when it actually died or otherwise, or he said it was lost when it actually died or otherwise, there's exemption from bringing an offering for this false oath. If the unpaid guardian denied ever having been made responsible for the animal and took an oath, he'd also be exempt. If the unpaid guardian claimed the animal was lost and took an oath, and then witnesses testify the guardian had eaten the animal, the guardian must repay the value of the animal. If the guardian had admitted himself that he had eaten the animal, he needs to pay a fifth charge and bring an asham offering for the false oath. If the guardian said the animal was stolen, and took an oath, and then witnesses testify he had stolen it for himself, he must repay double. If the guardian admitted to his theft by himself, he pays a fifth and brings an asham offering. If somebody accused another man of stealing his ox, and the man denies this, and then witnesses testify he had stolen it, he repays double. If witnesses testify he has slaughtered or sold it, the thief pays 4 or 5 times payments, depending on the animal. If a thief sees witnesses coming and then quickly admits to stealing the ox only, he pays the principal value of the ox. If somebody demanded his ox that he had lent to somebody and the man said it died naturally when it was actually stolen or otherwise, or he said it was broken when it had died naturally or other similar cases, and takes an oath for this, he would be exempt for the false oath. If a lender demanded his ox and the man denied ever having borrowed the ox and took a false oath, he would be liable for the false oath. If somebody requested their ox from a paid guardian or renter and they said it died when it had actually been captured or otherwise, and they take an oath, there's no liability for it being false. If they say the animal died or was captured or otherwise, when it was actually lost or stolen, they would be liable for a false oath. If the paid guardian or renters say it was lost or stolen when it had actually died or was captured and they take a false oath, they're exempt. The general rule is anybody who admits to liability but of a different type, or exemption but of a different type, is exempt for a false oath. If they change from liability to exemption, they're liable. Generally, if somebody takes a false oath to make things more lenient for himself, he's liable. And if it makes things more stringent for himself, he's exempt. The Gemara mentions the sages who source these points on the 4 different types of guardians, although it mentions there are technically only 3 laws between them, as mentioned. It's a debate by all these cases if there's not liability for false oaths of a guardian, although it's a debate if there's liability for false oaths of utterances. It discusses this and it brings sources for the former opinion that there is actually liability for false oaths of utterance. Although it said this would specifically not apply by the false oath of a borrower who says he has no knowledge of ever borrowing the animals, and the case of the paid guardian or renter where the animal was lost or stolen and they swear falsely that something unavoidable occurred to it, as in those cases there's liability for a false oath of deposit as he denied owing money. And that's the end of chapter 8 and the entire Tractate Shevuos. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. Under various circumstances, a person can take or be made to take an oath, or a shavua. There are severe liabilities for being dishonest while doing so. Such examples include requiring a witness to swear he has no knowledge of testimony, swearing a deposit was or was not received by yourself, swearing an oath to do or not do something, or otherwise. And that's about everything. Thank you so much for watching.